Perfect. Folks that weren't able to join today. So my name is Josh Ryer. I'm the Managing Director of Technical Staff here at the Connecticut Public Utilities Regulatory Authority. Hopefully you're in the right place. You're here for the pre-proposal bidders conference for PURA RFP 2022-05. Which is us looking for a consultant to help us with the 2023 annual RAM docket, and specifically looking at the prudency review portion of that docket. And I just want to kick things off, and I'll turn it over to my colleague, Julia Dumaine, to walk us through the slides. Really just to highlight the importance, the growing importance of this docket in what we do. There's several rate components that get set, get reconciled, and then all of the costs associated with those mechanisms are reviewed for prudency in this proceeding. And currently, many of those rates, or at least one of those rates are below zero. Currently, they're in total, they make up several, at least a couple of cents on customers' bills every year. So not an insignificant amount of costs, and it does include, and I'm really just thinking about the public policy related costs in that statement, whether it's the non-bypassable federally mandated congestion charge or the system benefit charge. Certainly, we also look at the transmission clause, adjustment clause, that's obviously a significant amount as well. So anyway, so that's all to say, we're looking at and setting rates in this portion of the proceeding that have a huge impact on ratepayers. And we want to make sure that we're doing our job, and thus are bringing on a consultant to make sure that we are thoroughly examining the prudence of these costs to make sure that ratepayers are only getting charged what they should be charged. So with that, I'll go ahead and turn it over to Julia to walk us through the details of the RFP, and both of us will be available at the end to answer any questions.
Great, thank you, Director Ryer. So yes, my name is Julia Dumaine, Supervisor of Strategy and Operations for PURA. I'm going to walk through some of the requirements of the RAM proceeding, as well as what we're looking for in a consultant or consultants, and the schedule for the RFP, as well as this proceeding. If you could just hold all your questions until the end, that would be great. So let's advance. So as Director Ryer mentioned, the RAM proceeding is an annual docket that we have to do a complete prudency review of the actual revenues and expenses associated with each of the components of RAM for each electric distribution company in Connecticut. So that's Eversource and United Illuminating. And then we approve any rate adjustments necessary associated with this review, which become effective on September 1st of each year. So that's important to note for the schedule of work products. There are a few statutory requirements. There's actually multiple, but beyond this, but these are the main ones that I'd like to highlight just for your reference if you'd like to do a little bit more due diligence on the requirements of Connecticut law in this regard. So Connecticut General Statute Section 16-19B outlines the procedural framework for reconciling our energy adjustment clauses and transmission rate adjustment clauses. Connecticut General Statute 19-19E subsection A requires PURA to examine these rates in accordance with a specific set of principles which are outlined there. And Connecticut General Statute Section 16-22 sets the burden of proof on EDCs in Connecticut. So just highlighting those for a little bit of additional context. I'm not going to go through everything on this slide because it's all included in the RFP itself, but our primary focus in retaining a consultant is ensuring that we have supplemental accounting and audit services for PURA staff to review each EDC's filings. Just to clarify, that means that there are two scopes of work here. There's one scope of work for the Eversource RAM docket and one scope of work for the UI RAM docket, so that we can, as Director Ryer said, ensure that the level and structure of our RAM rates are prudent and necessary. You can really distill our RFP scope of work into two sections. We have our discovery and analysis tasks, which is really assisting us in the discovery process and the review of an accounting analysis of all of the charges and credits made to the rate clauses, and just preparing other standard discovery tasks, such as preparing interrogatories or other prompts, written comments, cross-examination, things like that. And then we also will request advisement services in terms of how to evaluate the information received during the discovery process into our final decision. Our preferred, the consultant that we select, we kind of have 4 pieces of preferred expertise and experience that we're really looking for. So one is professional certifications, either as a CPA or certified financial analyst. We also are looking for consultants with knowledge of Connecticut energy policy, which will really require you being familiar with existing energy programs that have been authorized by statute and implemented through the regulatory proceedings at PURA previously, as those are incorporated through the NBFMCC. And then we, of course, as a utility regulator, would hope that our consultants have utility sector knowledge and any experience auditing public service companies. And then last is sort of related to policy knowledge, but experience with electric distribution company regulatory requirements, and particularly those in the state of Connecticut, and any experience with our Connecticut's rate adjustment mechanism in particular will be valuable. So this is the planned docket schedule as of now. So each year, we actually late last year issued a decision. The docket number is escaping me right now, but that standardized our RAM proceeding process, that really outlined the sequence of events in each annual RAM proceeding. So as of now, companies' complete RAM filings for the 2022 actuals are due on March 1st. Our hearings are scheduled for the week of May 29th and the week of June 5th. Any late file exhibit hearings will be in mid to late June. Briefs will be due late June. And then we plan to issue our proposed final decisions in each of the proceedings in mid to late July. And then over that period of time, we plan to have a final decision issued by mid-August, so that the September rate adjustments can take effect in time. I'm not going to go through all of the requirements of the proposal. We outline them in a table in the RFP that is pretty clearly describes what is required and the order that you should sequence your proposal. This helps us more efficiently review proposals and compare them so that we can execute contracts more quickly. And then we ask that you use the cost estimate breakdown table format also included in the RFP, and note that we need this for each the cost estimates to be done by RAM proceeding, as the contract will need to be one per proceeding, if that makes sense. And again, this allows standardization and more efficient review on PURA's part. So if you are interested after today in submitting a proposal, we request that you submit a notice of intent to bid. Just a simple email is sufficient to pura.rfp@ct.gov, just to notify us of your interest. If you have questions after today's session, we ask that you submit them all as one email or document by January 20th to also pura.rfp@ct.gov. We will issue responses and clarifications on January 27th. We'll submit them back to you via email, as well as posting them on the RFP webpage, which is available through PURA's website, and I can provide that link if necessary. And then proposals are due by the end of the day on February 3rd. And again, same email, We will reach out to you with any clarifying questions directly if needed. And then we plan to issue our selection by March 1st. We will also notify you if you were not selected. All right, so that was the quick overview. So we're happy to take any questions that you might have now. So I will open it up. If you want to, please use the hand raise function. I will call on you in the order that I see the hands come up.
And just real quick, Julia, the docket that escaped you was 220908, and I put that in the chat for folks.
Awesome. Thank you so much. Okay, I am not seeing any questions.
Hi, Julia. I'm not seeing the hand raise function. Sorry.
Oh, I think it
maybe
actually got moved. I think it is in like reactions now or something like that, but that's fine. Hi, Ryan. Thank you.
There you go. Okay, I just have a couple of questions. One is, how long has the rate adjustment mechanism been in place in Connecticut?
Yeah, that's a good question. At least for the past decade, the process itself. In 2000, we kind of reorganized how the process is done and split into these two distinct phases, where phase one is setting rates for May 1 and kind of provisionally approving the underlying costs, expenses and revenues associated with that. And then phase two being the more in-depth prudency review. So that's there's 2001 and 2002 where we've gone through that specific process, and then the docket that I highlighted 220908 then clarified that process going forward and consolidated some guidance. But the actual mechanisms themselves have existed predate that. And if you're looking for those prior dockets, they're all now, the year 0103 for Eversource, the year 0104 for UI. Previously, it was the year 0301 for Eversource, the year 0302 for UI, if you're looking for those prior proceedings.
Okay, that's helpful. And in the past, there were these prudency reviews were performed annually as well. So this isn't a new mechanism or process.
Yeah, correct. What I would say is that there's been a renewed focus or an increased focus on the prudency review over the last few years, partially due to kind of in the volatility of rates since COVID, and certainly the increase in rates as we've seen with supply rates, although that's not here, right? But just increased scrutiny has become in a public imperative, and certainly an imperative of our job. But then I'd also say that more and more of a large number of public policy related costs flow through these mechanisms, as you heard me allude to at the beginning. And those public policy costs, at least in magnitude on the cost side, not talking about the net benefits, but just the costs have increased in recent years as we deploy more clean energy or look at expanding new programs. So the need for increased scrutiny has also just naturally come out of that. There's more things. For example, we have an energy storage solutions program. So for behind the meter systems, which is new, and all of the costs are reconciled through this mechanism. So it's our opportunity to make sure that that program's being run prudently. Whereas that's an example of something that wasn't, included in this proceeding historically.
Okay, so the mechanism has been in place for some time, but the components are always changing and they've been expanded in recent years?
I would say the mechanism and the components have existed and stayed the same. The line items and the expenses that are included within those components has expanded and changed over the recent years.
Okay. Okay, that's helpful. I was also wanting to get some clarification about the procedural schedule itself. I know that there are, for each of the events, or for most of the events, there are a couple of dates associated with the event. Can I read that as, or should I read that as those events being associated with the different docket numbers? Those dates being associated with the different docket numbers, and that's why there are 2 dates associated with them?
I believe so. I will say I think this is just, correct me if I'm wrong, Julia, just summarized for simplicity. The full docket schedules, I think, are actually in our online docket system. I can check real quick.
Yeah. Josh, this is Stephanie. Sorry to interrupt here, but yeah, I would say, so Josh, the external schedules have not yet been posted.
Okay.
For 230103, which is the Eversource RAM, and 230104, which is UI RAM. With that said, we've done some internal scheduling, if you will, which is reflected here. So yes, to answer your question, Ryan, for example, the hearings on the 22 RAM reconciliations, we have separate hearings. We're kind of combining for this RFP and honestly for our planning purposes, because they're on similar timelines or tracks, but they'll have their own distinct hearing dates as associated with each docket. There's obviously some overlap in maybe some of the lines of questioning or the topics, certainly, but that's why you see, for example, the week of May 29th versus the week of June 5th. We have like a date or 2 days potentially scheduled for each respective docket along this timeline. The other thing that I'll say about the timeline is that it's inflexible, let's say, or that this is confirmed. Certainly with the final decision date issued in mid-August, as Julia ran through, and that's really dictated by previous procedural processes that Josh and Julia both spoke to about how, in order for any rate adjustments, additional rate adjustments to be effective beginning in September of that current year, we get the decision out and give the utilities essentially 2 weeks to kind of make any necessary tariff changes in that time frame, and that's really the latest it can be issued. And so that's kind of how we've worked backwards from the schedule. Something that's not reflected here, but just as the full picture of the schedule, is that we're also issuing interim decisions in each of these dockets to approve May 1 or May 2023 rates. Josh, feel free to jump in, but it's my understanding that based on the nature of this RFP process, that's not something that we're including in the scope for the consultant, but I just nonetheless wanted to make you aware that that's something that staff are, these RAM proceedings will be ongoing, essentially. If and when a consultant comes on board, there will have been some prior docket history there.
Yeah, I think that's right. The only, and that's good context for potential consultants to be aware of. To your specific question, Ryan, I can only say on the brief due dates, the proposed final decisions, the 2 different dates, that is reflective of 2 different dockets. And I would imagine, I think we already said the final schedule is still in our internal review process, but I would imagine that it will be posted externally in those dockets, the actual precise dates for the hearings and everything before the actual applications for the consultant applications are due.
Okay, that's
I can confirm
that's
that.
very helpful.
Yes.
Yeah.
Yep.
Okay, that's very helpful. And my last question is it is it PURA staff's preference that both of these dockets go to one consultant? And should the proposal assume that, or should the proposal potentially bid on one, the other, or both, and then have different pricing potentially, et cetera, for being awarded one, being awarded another, being awarded both?
Yeah, that's a good question. Is our preference to have one consultant for both? I think it helps with consistency and approach. That's something that's important to us in these dockets. So that would be our preference. Having said that, if there are pricing options or proposals that make sense from your organization's perspective to provide it based on docket, I would, by all means, we don't hate the optionality, but we would prefer to pick one consultant for both.
Okay, thank you. Thank you for the clarification, and thank you for putting this on. It's very helpful.
Okay, again, if you have a question, please use the hand raise function found in the reactions button, I guess, of your toolbar.
Well, one thing also that your question, Ryan, just made me realize too is we get this question asked all the time in terms of our budgetary constraints based on the statute in terms of what the proposal could be. And so to be clear, since there's the cap is 200,000 per proceeding. So in this case, if you're to submit a bid to help us with both, it could go up to 400,000. However, I mean, from my perspective, I wouldn't, based on the timeline and what's being asked. And we have rate cases going on, and knowing what the bidding that we've received in other similar dockets with a larger scope, I wouldn't anticipate. I'm afraid I'd be a little bit surprised if receive bids that high, but I just wanted to clarify that is in fact how the statutory cap gets applied.
Okay, not seeing any further questions. We are appreciative of your time and interest. As a reminder, once again, if you would like to submit a bid, please notify us via email by Friday. And if you have any further questions that come up, please submit them to us by January 20th. Director Ryer, are there any final things you want to say here?
No, I appreciate everyone's time and attention today.
Great. All right. Well, we look forward to hearing from you all, and thank you for your time.